Good afternoon. My name is Michelle Barkey, and I am the Senior Legal Counsel at Medcom. And we would like to thank all of you for attending this presentation today. And we're welcoming those that are joining us for the very first time. A few housekeeping items before we begin. This presentation is being recorded, and we will distribute the recording and a copy of the presentation within the next week. You may ask questions throughout today's presentations in the question panel on the GoToWebinar menu. Please feel free to stick around for the Q&A session following the presentation. We will have time at the end to answer any question that is submitted. Today's topic is penalty updates and the end of IRS forgiveness. First off, a little bit about Medcom. We have been in business for over 35 years now as a benefit administrating and consulting service firm. We were actually founded in 1983, and our home office is in Jacksonville, Florida, and we have a regional office in Atlanta, Georgia. Our solutions that we offer are multifold. First off, we do have HIPAA privacy and security solutions. For any self-funded plans or fully insured plans that actually transmit, receive, store, or maintain electronic personally identifiable health information. We have a department that deals with health and welfare compliance, which deals with WRAP plans and NDT determinations and any other questions that come up under ERISA. We have COBRA premium billing and services, so we actually are a COBRA administrator. We do have a fringe benefit department that does the consumer-driven health plans, such as HRAs, HSAs, and we offer consulting services for those as well. And then today we're going to be talking about the Affordable Care Act. It's hard to believe that we've been dealing with the Affordable Care Act going into the 5th year now, and we do consulting, compliance, reporting, and we've done a lot of appeal support over the past couple of years since the IRS has started to impose penalties. So basically what we're going to be talking about today is what we have seen from the IRS and the trend that is coming. And it seems that the IRS is now not as forgiving as they were before, even when we filed for those appeals. So first off, let's talk a little bit about the IRS and what their mission statement is. And it helps to put it all in context. The mission statement of the IRS is that it provides American taxpayers top quality service by helping them understand and meet their tax responsibilities and enforce the law with integrity and fairness to all. So that's what the IRS says their mission statement is. Then they go on and they elaborate a little bit more as to what their role is. And they make it clear that it is the United States Congress that passes the tax laws and requires taxpayers to comply. And the Affordable Care Act was actually passed under IRS Revenue Code statutes and is deemed to be a tax. So the United States Congress passed this and we're all stuck with it, but we have to comply. The second thing the IRS says, the taxpayers have obligations too. The taxpayer's role is to understand and to meet all their tax obligations. And the IRS's role in all this is to help the large majority of compliant taxpayers with the tax law while ensuring that the minority who are unwilling to comply pay their fair share. You never want the IRS to determine that you're in that minority who is trying to beat the taxation from the IRS standpoint. You always want to make sure that you understand and meet your tax obligations. So under the Affordable Care Act, applicable large employers do have obligations. So what are the obligations that we have? And then that puts it in perspective as to how the IRS is viewing it. We have two obligations. The first is under 4980H-A and B. This is the Employer Shared Responsibility Mandate, where applicable large employers must offer coverage to 95% of their full-time employees. The coverage must be affordable, and it must meet minimum actuarial value. If you fail to do so, there's a tax consequence that the IRS collects. And the second obligation that applicable large employers have is they must report to the IRS, and this is under Section 6055 and 6066. Now, 6055, it's still up in the air this year a little bit because in 2019, the individual mandate was reduced to zero, but the individual mandate penalty was reduced to zero, but the individual mandate did not go away. So it seems that the IRS still wants us to report on the individual mandate, and this comes under Section 6055. This is where the insurance companies will send out a 1095B indicating who had coverage, and again, that was for the individual mandate. And self-funded employers have to complete Part 3 of the 1095C, indicating who actually accepted the coverage. Again, all for the individual mandate. Section 6066 was the employer mandate. It said all applicable large employers must report on the coverage they either offered or did not offer to their full-time employees. Failure to do that can result in penalties as well, and that's where we're seeing the IRS is becoming a lot less forgiving. Now, under Section 4980 HA, just for a review actually, if you fail to offer coverage to 95% of your full-time employees, you face what we call the sledgehammer penalty, where you are penalized on all your employees minus the first 30. And these are the penalties, and as you can see, they have grown up. In 2015, it was $2,080 or $173.33 per employee per month that you fail to offer when you fail to offer coverage, and that's to all your full-time employees. And now in 2020, it's going to be $2,570 or $214.16. So again, the penalties are getting higher, and you must offer coverage to 95% of your full-time employees or face a sledgehammer. Now, if you fail to offer coverage that was affordable, you've offered coverage to 95% of your full-time employees, but it wasn't affordable or it didn't meet minimum actuarial value, then you're only penalized on those employees that actually went to the marketplace and received a subsidy. Penalties are a little bit higher, but you're not paying on all your full-time employees, just those who went to the marketplace. And again, you can see over the years, the indexing, the penalties have gone up substantially from 3,120 annualized to 260 per month per employee that went to the marketplace. And then in 2020, it's going to be $3,860 or $321.66 monthly. And again, you only pay for those individuals who go to the marketplace. Now, the next thing that the IRS is looking at is for those employers who they believe to be applicable large employers who fail to furnish the employees with the 1095Cs or fail to file those with the IRS. They assume if you didn't file with the IRS, you did not furnish, so the penalty is going to be on both failure to furnish and failure to file. Now, you get this if you don't timely finish the 1095C to all full-time employees, and you don't timely file the forms 1095C and 1094C with the IRS. You also have to make sure the forms are accurate. For the past 4 years, we've had good faith, that you had to make a good faith effort to get the forms correct. But if they weren't and you had a reason and you made that good faith, the IRS didn't penalize you. We do not believe that's going to be the case going into the 2020 reporting year for 2019. And if you are filing more than 250 forms with the IRS, it must be done electronically through the IRS AIR system. Failure to do so will result in a penalty. So what are the penalties? Well, these are per form. So it's $250 per form that is not filed on time, $250 for a file that was not furnished on time to the employee. And in 2015, that was up to a maximum of $3 million. Now, in 2018, it went up to $270 per form, and the maximum penalty could be $3,275,500. And I know all of you just can't afford that kind of money going out to the IRS in pure taxes. So taxpayers' obligations if time runs out. If employees have noticed that they're not going to be able to get their 1095Cs finished to the individual on time, you just can't ignore that. You've got to ask the IRS for an extension. And when you ask for the extension for the employees to finish it to the employees, you may or may not get it. It has to be in writing, and it's up to the IRS as to whether or not you have discretion. Typically, the forms are due the last day of January, January 31st, unless it falls on a Saturday or Sunday, and then it would be the following Monday. Forms to the IRS must be filed by March 31st of each year, unless it falls on a Saturday or a Sunday, and then it would be that Monday. Now, again, that's not the April 15th deadline that employees have to file their individual taxes. You've got to get this done by March 31st. In the past, the IRS has given a 30-day extension to us for the employee for finishing to the employees, but more recently they have not given any extensions for the filing. So you've got to get that done on time. If you fail, or if you come up to the deadline and you know you're not going to get it done on time, you just can't ignore that and just get it done when you want to. You must file a Form 8809 with the IRS. That form goes through the fire system, and it requests a 30-day extension. And that's an automatic 30-day extension for filing with the IRS, unlike for furnishing to the individual where the IRS could approve or maybe not approve it. This is an automatic 30-day extension. But after the 30 days, you only get additional time if you can prove that there is a hardship. Something catastrophic happened. For an example, a hurricane comes through and knocks out all the power, and the area is devastated. The IRS would give an extension in that case. So the next thing is the obligation of the employers who have more than 250 forms to file with the IRS. They must be filed electronically. You just can't mail them. And we have seen clients that mail these forms and then they come back to us and they said, yeah, but we mailed them. And we say, how many forms did you mail? And they said, well, maybe 500 or 1,000. We even had one that had substantially more than that. You can't do that. And if you have to file by mail and not electronically, you have to complete Form 8508 at least 45 days before the IRS due date. IRS due date is March 31st, so this form would have to be put in by January, middle of January. And when you have this form, it's not an easy form to complete. The IRS wants to know why you can't file it electronically. They want to know the steps you have taken to meet the requirements, an estimated cost of filing electronically, a detailed computation supporting the above, so you actually have to show them that you got quotes and everything else to file electronically, the value of the entity's total assets, so how much money do you have, and then the steps taken to assure the ability to electronically file in the future. So this is not an easy form to complete, but you can't ignore it. You can't just file it by mail and then say, hey, I'll wait for the IRS on the back end. Chapter 7 bankruptcy is usually an acceptable excuse if you haven't been able to get your systems together. And again, a catastrophic event, for an example, a hurricane, if it comes down and wipes out all the systems and all the processes, the IRS will probably forgive that. But again, you've got to document it. So let's look at what the IRS is now doing. Don't forget, the IRS says Congress passes the law, employers and taxpayers, our obligation is to know the law and to comply with the law, and that means all the nuances, what forms need to be filled out, when requesting extensions, when if you have to file it by mail rather than electronically. And the IRS's role is to enforce it, to make sure that all taxpayers are doing what they have to do, and to make sure that it's fair and equitable. Not fair and equitable if the IRS thinks that you're one of those employers who are just not paying attention while a lot of other employers are paying attention and trying to get it done and trying to get it done right. So, what happens if you did not offer coverage to your full-time employees, or if you did offer coverage that it failed to meet minimum actuarial value or wasn't affordable? Well, the IRS is going to send you a letter 226J at that point, and it gives you a table of penalties, what they're charging you for. The A penalty, the sledgehammer, failure to offer coverage to your full-time employees, or the B penalty, which is you offered the coverage, but it wasn't affordable or did not meet minimum actuarial value. Again, you can't be charged in the same month for both A and B. You can only be charged one or the other. One excludes the other. And you have 30 days to comply once you get this 226J letter. They'll also send you two forms with it, a 14764, which is just a statement whether or not you agree with their computation or not. And if so, please send us a payment. And the second one is the 14765, where they actually outline all the employees that went to the marketplace and received a subsidy, because all penalties are based on the fact that an employee goes to the marketplace and gets that subsidy. And on this, it tells you how it was coded when the forms were initially submitted, and then you get to complete and say whether or not the coding was accurate and how you're going to correct the coding. So far, we have not seen the IRS charge any penalties for an incorrect code once we've changed it on a 14765. We've had good faith years, 2015, 16, 17, and 18. 2019 may not be a good faith year, and it may be that penalties will be assessed for a failure to file a correct form. And those penalties are that $270 per form that's incorrect, but a whole lot better than the penalty that is associated with the A or the B penalty. Now, the IRS is getting aggressive. For an example, we had one client who came to us because they got a 226J letter for 2015. What seems to have happened is the IRS went through a wave and they gave us 15 letters, 16 letters, and 17, beginning of the 17 letters for the employer mandate. But now it looks like they've been able to identify a lot better, so they've gone back and they've started with 15 all over again. So we expect more waves of 15, 16, and 17. And in this case, in 15, they had transitional relief. They were an applicable large employer, but they had between 50 and 99 full-time employees, including full-time equivalents. And we made that argument to the IRS saying, hey, they were between 50 and 99 entitled to transitional relief, met all the requirements for transitional relief. Please do not penalize them. And the IRS came back and said, prove it. So we had to go back to the 2014 calendar year, get the payroll, and do an ALE determination to send off to the IRS that proved that, yes, indeed, in 2015, they were between 50 and 99. So the IRS is getting more aggressive, and they are not just accepting things at face value. So the appeals are becoming more and more important, and more documentation is being required. We've had to provide proof of part-time status when originally the person was coded as full-time, and we've gone back at looking at the 14765, realized the person was part-time, and the IRS says prove it, so we have to get the payroll records. So again, the IRS is getting much more aggressive, and we just never know when we're correcting those codes from on the 14765 whether or not the IRS will eventually come back and say, hey, you did the forms wrong, now we're going to penalize you that $270 or whatever it was in that appropriate year for filing an incorrect form. Hasn't happened yet, but it can, and we're just waiting for that. But again, we have good faith arguments that it was still done in good faith, and that's good. So the only way to resolve these employer shared responsibility penalties is based on whether or not they were an applicable large employer, whether or not they did offer coverage, and whether those employees that went to the marketplace and received the subsidy were in fact full-time employees for any of those months, whether they were offered coverage and declined the coverage, whether the coverage met minimum actual value, and whether it was affordable. In short, we have to look at everything as if we were doing it with fresh eyes and doing the filing and the coding at this time. and proving to the IRS that, yes, indeed, everything was kosher. In short, when you're looking at that, it is all fact-driven. The IRS cannot collect penalties if you do not owe them in this situation. However, failure to file or failure to furnish, the IRS is sending out letters 5699 when they feel that an ALE did not report. Now, if you didn't report, how do they know that? They think that you're an ALE? It's not difficult. They look at how many W-2s you sent. And if you send an appropriate number of W-2s, then they think, you know what? You had this many W-2s, you must be an applicable large employer. And they're basing the total counts on how many W-2s you file. So they just match it up, and then they say, hey, were you an applicable large employer? If yes, did you file? And if you said no, the next question is, can you file within 60 days? And if you get it done within that 60 days, those back filings, to date, they haven't been penalizing you, but that doesn't mean that that's not going to continue, that they may start penalizing you. Now, failure to respond to this letter is not a good idea. The IRS gets much, much more aggressive, and that you get a 5005A letter along with a Form 886A, and this is basically a payment letter. We believe that you didn't answer our letter. You must think that we're right. Therefore, the proposed penalty is this much. Now you have to take it an extra step with the IRS and now explain why you didn't reply to their first letter and potentially go through an additional appeal process. So the stakes are much, much higher now in this regard. Now, we're also beginning to see letter 972CG, and this is the new tough, no-nonsense letter from the IRS for an ALE that did not file on time, for an ALE that did not file electronically when they should have, and it will also be the letter for the ALE that did not file the codes correctly when they start issuing those penalties. How tough has the IRS gotten? Well, we had one that for 2017, an employer that filed just a little over 30 days late, they charged him a penalty. Now, at that stage of the game, they charged him a very low penalty. It was $50 per form because he did it within the 30 days. But again, he still got charged that late fee. We have seen them where they've mailed the 972CG letter to an employer that had 325 forms, and they penalized him for the 75 that were over the 250. And when you get this 972CG letter, you only have 45 days to respond as to what happened and whether or not you have any legal argument. Now, the first steps in responding to these type letters is to determine if the allegations are correct. Did you file on time? Did you file correctly? Did you file electronically when you should have? Do you have your receipt that you filed it electronically? Second step is to determine if the IRS counts are correct. If you didn't file, they're relying on the W-2s. Well, the W-2s might have some part-time employees in there, and they might have some employees that were only there for a couple of months rather than all 12 months, of which you're being penalized. And again, it's just per year, it's $270 for the form. But there's things there that you can potentially look at and determine whether or not they were a full-time employee and whether you did need to finish them the forms. And the third step is the most difficult, and this is to convince the IRS that there was a reasonable cause why you did not file with the IRS on time or you did not finish the forms electronically. Reasonable cause is a tough standard. And again, if you didn't do what you were supposed to do by filing the extension form, if you didn't do what you were supposed to do by filing the form that said, hey, I can't file electronically, these are all my reasons, and you didn't file it within 45 days, then the IRS is going to have a much more difficult time believing that you had a reasonable cause. You want to always be able to convince the IRS that you want to voluntarily comply, that you're not one of those taxpayers who doesn't want to comply, that you do try to understand your tax obligations, that you take the IRS seriously, and that's always your goal. you must prove that you are not one of those taxpayers who are willfully violating the IRS regulations. Again, it goes back to what the IRS says. Congress passes the law. The taxpayer has to understand and take all appropriate steps to file correctly and on time. And the IRS's role is to help the taxpayer understand, but to penalize those who do not. So you need to convince the IRS of that. Now, reasonable cause is a tough sell. According to the IRS publication 1586, you have to show that you acted in a responsible manner both before and after the failure occurred, and that there were significant mitigating factors with respect to the failure, or the failure was due to events beyond the filer's control. So what did you do before? How did you react? When you found out that you were not compliant, what did you do? What appropriate steps were you taking? And really, basically, everything that goes into this reasonable cause determination is anything that comes up as to what happened and why you didn't file on time or why you didn't file electronically. These cases are no longer just a question of fact. They require analysis and application of reasonable cause, and sometimes even looking at the case law. Now, I will tell you the courts have not been favorable to taxpayers. They believe that you have to file your taxes on time, and there's not that much that the courts have forgiven. In fact, the United States Supreme Court in 1985 said reasonable cause was not found when an executor of a state relied on the advice of his lawyer and taxes were not timely filed. Taxes on an estate must be filed within 9 months past death, and they thought they had until the following April 15th. They did not. They didn't file it on time, and he said, hey, but my lawyer told me that. And the Supreme Court said no. They said, you are responsible for your taxes, not your lawyer. You are responsible. You are responsible for making sure that you understand. Now, you can always go back to your lawyer and sue him, but the IRS is suing you, and you have to pay up to the IRS plus all the penalties associated with it. Now, in a 2019 case, this actually kind of cemented Boyle from 1985. It was a really interesting case in which there was a couple that obviously were fairly wealthy, and they went into their tax preparer, and he was electronically filing their returns. And then after they electronically filed their returns, thinking that they were safe, they went overseas and they were in Europe, and all of a sudden they get a notice from the IRS that they owed $126,000 because they had not filed their taxes on time. They went back to the tax preparer, who looked at the record and found that she had not pushed that sent button. And they tried to explain to the IRS that, we live in a completely different age now. Boyle should not apply. We relied on the taxpayer, but in the electronic age, this is a whole different story. Other things can happen, and this was completely inadvertent on the tax preparers, to hit that send, and it was a real mess, and here we'll pay you what we owe you, but we don't think we should owe the penalty. And the court said, no, you are still responsible. You didn't get a receipt. You didn't get anything. You should have checked out that everything went through and that you've got a confirmation to that. And it was not forgiven, electronic age or not. And then in another case in 2018, don't even try to use a family member's illness or incapacity and that you're too busy to file your taxes. You can always get an extension on an individual tax until October the 15th, I believe it is. And on the employer mandate, if your HR person is going to be out, you got to make sure that somebody else there knows what they're going to do to get those taxes filed on time, and potentially ask for that 30-day extension for the filing with the IRS. But again, you just can't use that as an excuse. So again, the courts have not been favorable to the taxpayers. So the IRS knows this. The IRS is enforcing their obligation, which they say is to make sure that the taxpayers pay on time, and that they will come down on those who do not. And we're beginning to see it more and more. At the beginning, when we first started to get the 226J letters, you know, for the employer shared responsibility, and we first started to get these notices, the IRS was really pretty easy to work with. But now they probably have a mandate that they've got to get tougher. And you know, it's been 4 years now, and they're tightening up. And I would be very surprised if we had another good faith year now, or if we have another, you know, extension, because we've been doing this now for 4 years, and sooner or later the IRS starts to enforce. We've certainly had enough feedback from the IRS over the last 4 years with all the penalty notices that have gone out and people realizing what their mistakes were. So you've got to make sure that you get it done, and you get it done timely, and that you hire a vendor who can do it and do it correctly the first time. Now, MedCom, we have been doing a lot of the penalty appeal support, and so far we've saved well over $30 million in projected penalties to date. We've had great success with the IRS, but we're also very, very detailed in our responses to the IRS, believing that if we make the IRS's job easy and give them all the information they want up front, then we have a much, much better chance of success. But again, the IRS is getting tougher and tougher to deal with. Now, MedCom services for ACA, we do have ACA reporting services. You get us the data on time, we'll get it out on time. If we need to get an extension, we'll let you know, and we can get those extensions filed. We know what forms to file. We do the employee penalty support, you know, and we've seen a lot of coding mistakes over the past 4 years. Again, the IRS is not going to be so forgiving with coding errors in the future. We do have employee call center support when those employees get the 1095Cs and they say, what are these? They've been getting them for 4 years now, but there's always questions. And then always strategic evaluation and consulting to let you know what your obligations are and how to best go about handling the ACA. Don't miss out. You know, we're going to hit capacity soon if you want to use our services. We are accepting new ACA clients, but again, like every other vendor, we have to have deadlines because the IRS imposes deadlines. And the employee, to finish it to the employee, it's going to be January 31st this year, so we've got to make sure those deadlines are met. So at that stage of the game, are there any questions? I see one question. If we offer healthcare coverage to retirees, do those retirees count as full-time employees for the 95% requirement? No, they do not. Retirees are not a full-time employee. They have retired. For the portion of the year, if they're a portion of the year that they have worked for you, then for that portion of the year that they've actually worked, they are counted in the count. But if they're just pure retirees for the full year, they are not. And there's a special code that you use on the forms to let the IRS know that they are a retiree and that they do not count. Do we need to mail a 1095C to retirees who are covered? And the answer is yes. And again, it's because of that individual mandate. Now, again, and that's if you're self-funded. You do not have to provide a form if you're fully insured, because the insurance carrier will do that. So you only give a 1095C completing Part C3 if you're self-funded. Otherwise, you do not have to give retirees forms if they've been a retiree for all 12 months, because the insurance company on a fully insured group will take care of that. If an employer determines they did not file for a given year, should they bother when there are fees for not filing on time? And the answer is yes. Like everything else with the IRS, remember we said reasonable cause, what you did before and what you did after count. So you always want to make sure that you get your filings done. Sooner or later, the IRS is going to catch up to you, just as they do with the individual files, and you have to do the filing and the back filing. So the answer is absolutely, you've got to get these filings done on time. I want to confirm that the 250 form total is by DEIN employer and not by common ownership with multiple FEINs. Yes, 250 forms is going to be, I believe, for each individual EIN. You can file the 250. Will you send this recording out to participants? And the answer is absolutely. You'll have the recording as well as the presentation out by next week. Is there anything special we should do if we are going to from fully insured to self-funded mid-year? And the answer is yes, because once you go self-funded, then you're going to have to complete Part 3 of the 1095C, indicating who had coverage when you went self-funded. The insurance carrier will take care of that from January until your date of self-funding. You take care of it after your date of self-funding. So that's one of the things that you have to do. And if a group is not an ALE, but they are self-funded, are they required to file for ACA? And that's a really good question. And the answer is, to this point, yes, because you're reporting on the individual mandate. Now, you don't have to complete a 1095C. You could complete a 1095B. No, you'd have to complete you could do a 1095B indicating who actually took the coverage, because we're talking about the individual mandate. Now, the individual mandate penalty has been reduced to 0 as far as 219 is concerned. We have not heard to the contrary that the IRS is still not going to try to collect this information, because the mandate still exists even though the penalty has been reduced to 0. In fact, the forms have not come out yet, even in draft format, for the 1095B or the 1095C. But the schemas actually came out last week for the electronic filing, and it seems to indicate that they're still requesting this information. So if you are under 50 and you have self-funded and you offer coverage, then under 6055, you have to report the coverage that individuals actually took, not that you offered. So I guess that's all the questions that we have, and we really do want to thank you for your participation. And I am going to look at that question and send the answer as far as the 250 forms. Is it by EIN or is it by the total group? I'll get that answered out to you just to confirm, but I think that you can do it by EIN. But I will check that and let you know for sure. So I think that's all we have today, and I thank you very much for your attendance.